Stop Domestic Violence. Various photographs have been used in this booklet. These will be acknowledged at the end of this booklet.
Stop Domestic Violence. What you need to know.
Page 3.
Put a stop to domestic violence. The Domestic Violence Act 116 of 1998 allows a victim of domestic abuse or violence to seek a protection order from the magistrate's court against the person who is committing the abuse. The purpose of this guide is intended to give the victim the information that he or she needs to bring an application for a protection order in terms of the Domestic Violence Act. Both men and women can be abusers and victims of domestic violence. However, for the purposes of this guide, the victim is considered as a woman. What is domestic violence? In general, domestic violence may be an ongoing pattern of coercive control, increase in severity over time, be complicated due to the fact that the victim and the perpetrator often share financial, social, and familial ties. Forms of abuse in terms of the Domestic Violence Act. Physical abuse may include shoving, slapping, punching, kicking, throttling, biting. Assault with objects, guns, knives, or any other dangerous weapons. Sexual abuse may include rape, attempted rape, indecent assault. Ongoing verbal abuse with sexual slurs such as bitch, whore, slut, etc. Emotional, verbal, and psychological abuse may include constant insults, ridicule, or name-calling. Repeated threats of violence or death to cause emotional pain.
Page 4.
Economic abuse may include selling of a shared property, for example, livestock, matrimonial house without the consent of the victim. Accessing a joint bank account for personal use without the consent of the victim. Intimidation could be sending written or verbal death threats to the victim, sending beheaded dolls, small coffins, dead flowers, or dead pets to the victim. Harassment may include repeatedly watching the victim outside or near her house, workplace, school or business premises, or any place where she happens to be. Repeatedly phoning the victim or causing any other person to phone her, whether or not the caller speaks to the complainant. Stalking means, for example, constantly approaching the victim and asking or demanding to talk to her against her will. Damage to property may include acts of breaking the window to gain entry into the victim's house, cutting, breaking, or damaging in any other manner shared furniture. Unauthorized entry into the victim's residence may include using a duplicate key to gain access, may also constitute domestic violence.
Page 5.
Both men and women can be guilty of and be victims of domestic violence. Who can apply for protection order? Any person who is the victim of an act of domestic violence may apply to the court for a protection order. The application may also be brought by any person who has a material interest in the well-being of the complainant, for example, parent, social worker, teacher, etc. Any unassisted minor or any person on behalf of the minor may apply for a protection order. The application may be heard in camera. in private. The complainant or respondent may be allowed not more than 3 persons for purpose of providing support. The protection order is valid for life and is enforceable throughout the Republic. Against whom may you seek protection? It must be a person that you have a domestic relationship with. For example, the person to whom you are married, whether by civil or customary rights. Your partner, whether of the same or opposite sex, who lives or has lived together with you, even though you were not married to each other or are not able to be married to each other, if, for example, one of you was already married to someone else. The other parent of your child, or persons who share parental responsibility with you for a child. Persons who are related to you by blood ties, marriage, or adoption. The person with whom you shared an engagement, customary or dating relationship, including an actual or perceived romantic, intimate, or sexual relationship of any duration, for example, one-night stand.
Page 6.
A person with whom you share or have recently shared the same residence. What must I do? If you are a victim of any act of domestic violence as listed above, approach the local magistrate court and request assistance to apply for a protection order. The clerk of the court will assist you to complete the necessary forms and take you before a magistrate, who will determine whether to grant the interim protection order or not. The details of service providers who can give advice and help you in this regard are provided at the beginning of this guide.
Page 7.
Remember that in case of emergencies, this service is available 24/7. Which court should I approach? Approach the court nearest to where you live or work. If you were forced to leave your place of residence as a result of the violence and are living elsewhere temporarily, you may approach the court closest to your temporary residence. What is an affidavit? An affidavit is a statement made under oath. This means that the person who is making the statement has sworn to speak the truth and is aware that he or she will be prosecuted if it is found out that the contents or parts thereof of the affidavit are untrue. It is a punishable offence in a court of law to make a false statement. When can I apply for interim protection order? If the respondent is committing any acts of domestic violence, I may apply for the protection order. The court will consider my application, and if the court is satisfied that there is sufficient evidence that A. the respondent is committing or has committed an act of domestic violence, and B. undue hardship may be suffered by me, the applicant, as a result of such domestic violence, if an interim protection order is not issued immediately.
Page 8.
What will the interim protection order state? The interim protection order will request the respondent, the person who is committing the abuse, not to abuse you in the specific manner alleged in your affidavit. For example, order the respondent not to sexually abuse you or your children. In extreme cases, the magistrate may consider it appropriate to prohibit the respondent from entering the shared house or certain areas of the shared house, for example, your bedroom. If the children are victims of the abuse, the court may order that the respondent has no or limited contact with the children. The court may make an order for emergency monetary relief. This means that if you need to claim medical expenses or alternate accommodation costs, which arose directly as a result of the abuse, you must provide proof of the expenses incurred and request the court to consider this application. The court may order the police to seize the respondent's firearm if he or she has made any threat on your life. To fully appreciate the nature of the alleged abuse, the court relies on your affidavit. You must therefore provide the court with all the relevant information in your affidavit, for example, details of the incidents of abuse, the date and place and nature of the last incident.
Page 9.
What do I do with the interim protection order? The interim protection order must be served on the respondent as soon as possible. You cannot personally serve the order to the respondent, as this will not constitute proper service. In other words, handing over the interim protection order is the responsibility of someone in an official capacity, i.e., a police officer or sheriff. You must take the interim protection order to the office of the sheriff or to the police station closest to the respondent's residential or work address. At the police station, please remember to take down the name and/or badge number of the police person to whom you hand the order. This enables you to easily track the order at a later stage. Most police stations have a designated officer to handle domestic violence matters. Arrange with the police officer to collect the return of service, or proof of service. This proves that the interim protection order has been served on the respondent and that he personally received it. Do not arrange for the police to deliver or post the return of service directly to the court, as this is often too slow and does not get to court before the return date.
Page 10.
Remember that in terms of the law, the police must assist you in whatever manner stipulated in the court order. For example, with the collection of personal belongings, your ID document, children's books or clothes, etc. If you find that the police officer is unhelpful and refuses to cooperate in terms of the order, you may report this to the Independent Complaints Directorate. Note well. Also note that it is not the duty of the police to assist you with the removal of furniture, computers, crockery, etc. What do I do with the proof of service? You will need to provide the clerk of the court with the proof of service of the protection order as soon as possible. Once the clerk has this document, the court will authorize a suspended warrant of arrest for the respondent. This warrant may only be used against the respondent for any future violations of the protection order. What is the return date? The return date is the date set so as to allow the respondent the opportunity to show why the final order should not be granted against him. What happens on the return date? The court must hear the matter and consider any evidence or any affidavit as well as oral evidence. If the court is satisfied on balance of probabilities that the respondent has committed or is committing an act of domestic violence, a protection order must be issued.
Page 11.
Will the respondent be arrested with the protection order? The respondent will not be arrested upon service of the protection order. It is only upon a breach of the terms of the order that the respondent may be arrested. What is contempt of court? This is when the respondent who has breached the order has failed to appear in a criminal court to answer the charges laid against him. What is a breach of the protection order? This is when the respondent fails to comply with the conditions of the protection order. For example, when he repeats the abusive behavior that, according to the protection order served, he has been prohibited from committing. Will there be a formal hearing? If the magistrate is unable to make a decision on the affidavits presented to him because of the conflict of facts between your version and the respondent's version, i.e., if there's a dispute in the information given by both parties, the magistrate will postpone the matter for a formal hearing. At the hearing, both parties will be required to give oral evidence under oath and to be cross-examined by the other party. However, the respondent is only allowed to ask complainant questions via his attorney or the magistrate. Both parties may call witnesses to give any other supporting evidence that they need to prove their case. For example, medical certificates, hospital records, photographs, documents, etc.
Page 12.
Any child in the care of the complainant is considered as an indirect victim of domestic violence. The Act therefore allows such child to apply for a protection order against the respondent.
Page 13.
What if the protection order is breached? If the respondent breaches the protection order by continuing to subject you to any form of abuse described at the beginning of this brochure, you may lay a criminal charge at the nearest police station and hand in the warrant of arrest to the police, who will then arrest the respondent. Remember, however, that if the court finds that the warrant of arrest is used maliciously to have the respondent arrested without just cause, then you may be prosecuted in terms of the Act. Can the criminal charges be withdrawn? Once the respondent has been arrested for a breach of the protection order, the applicant may not decide to withdraw the charges. The Director of Public Prosecution or senior member of the prosecuting authority designated thereto by such director has the sole discretion to withdraw charges. Can I set aside the order? You may at any time make an application to have the order set aside. It is, however, at the discretion of the court as to whether or not to set aside the order. This will mean that the protection order will be declared null and void.
Photo Index. The following is a list of photographs that appear in this booklet. Cover page. An open hand with a teary eye appears through darkness, seen through torn and broken paper. Page 1. A clenched fist that is being blocked by an open hand. Page 4. A silhouette of a male raising his hand to a female who is blocking her face with her hands. Or, a silhouette of a male raising his hand to a female who is shielding her face with her hands. Page 6. A blurred photo of a woman clasping her hands. Page 7. A woman covers her eyes with her hands. Page 8. In the first column, the photo is of the court gavel. In the second column, the photo is a poster listing the various forms of abuse. Page 9. The photo is of a police constable's badge. Page 12. The photo is of a barefooted child standing with a fluffy teddy bear that is half dragging on the floor. Page 14. This page has been left for you to jot down notes. Page 15. Young hands hold the hand of an elderly person.
Useful numbers. People opposing women abuse. POWA 011 642 4345. Stop Women Abuse 0800 150 150. Adapt 011 885 3332. Domestic Violence Network 012 321 4959. NICRO Crime Prevention 011 403 2953. South African Human Rights Commission 011 484 8300. Childline 011 938 8745. FAMSA National 011 833 2057. Lifeline 011 728 1347 or 0861 322 322. Commission for Gender Equality, CGE 011 403 7182. Independent Complaints Directorate, ICD 012 320 0431. Police National 10111. For more information, please contact the following: Department of Justice and Constitutional Development, Chief Directorate. Promotion of the Rights of Vulnerable Groups. Telephone 012 315 1111. Fax 012 315 1851. www.justice.gov.za